Okay, ladies and gentlemen, we're going to go ahead and get started. I will call to order the Juvenile Justice Committee meeting. Today we have 4 issues on the agenda. For the sake of brevity, Representative Wiedauer, sorry, blanked. I'm going to have you kind of present your 2 bills. I believe you have something that you'd like to say on House Bill 403. And then you'll be doing a full presentation on House Bill 322. If you'll hit, what is your mic number so I can? Okay, try it.
How about that? Yep. All right. So 403, House Bill 403, LC 41, 2841. What this seeks to do is really create an environment where we make sure that attorneys that are representing children are properly trained and vetted. There are some other programs out there that seek to do this. We feel like this measure would actually enhance that. But as the chairman and I have met, I think we're going to continue to work on that. But it is something that we're looking to do for the Department of the Child Advocate, is to create this guardrails of training for the attorneys that are representing children and are representing them as child advocates.
Okay, thank you. Would you like to proceed with your second bill?
House Bill 322, LC 41, 2860. We're updating the definition of sexual exploitation in the juvenile code because prostitution is a juvenile cannot be charged with prostitution. We're striking that from the definition of sexual exploitation for a juvenile. It's really a cleanup because it, again, prostitution rendering mute in this part of law. That's the extent of it. You can see throughout the bill on lines 25, 33, and 45 where it strikes that in the code. Simply that. We've talked with PAC. Everybody seems to be on board with the update of this definition.
Okay. Thank you very much. Ladies and gentlemen of the committee, do you have any questions of Representative Wiedauer? No questions either here or online. Are there any questions online? No. Okay. No questions. What is the will of the committee? There is a motion to pass from Chair Oliver. Is there a second?
Second.
There's a second from Chairman Blackman. All those in favor of passage of the bill HB 322 authored by Representative Wiedauer. All those in favor of the passage of the bill, please signify by saying aye.
Aye.
Aye. Aye. Aye.
Okay, thank you. Your bill passes. Thank you. Second, we're going to call Representative Scoggins.
Okay, thank you, Chair and members. I bring to you today House Bill 464, and this bill is relating to temporary guardianships of minors. We worked on this bill. The probate judges and I worked on this bill a good while, and we even at one point we were ready to transfer sole jurisdiction over to the juvenile court, simply because we felt like that's where it belonged, and it needed to be in juvenile court. But we've kind of come back and kind of changed the bill a little bit. And what we've done, if you're familiar with the law, temporary guardianships in the probate court, as the law is written, the law says that we shall order the guardianship. It doesn't give us any leeway. It doesn't give us any right to, if we don't like the way the guardianship's going, if it doesn't look exactly right, we don't have any right to so-called deny the guardianship. The law says we shall. So what this bill does is it gives the probate judge a chance to transfer the case to juvenile court. It's not to say all cases are going to juvenile court, but it gives us the opportunity to transfer the case to juvenile court if it doesn't look good. We've heard many war stories on these temporary guardianships. These things first were created back years ago, before there was a juvenile court. They were in probate court. And what happened was, as time went along, this law was put in for like people going into the military that could give temporary guardianship over to someone for kids, or when they're off at war, and it kind of grew and got out of hand. DFACS was kind of abusing this program. What they were doing is they were telling their people to come down and do a temporary guardianship in probate court so they wouldn't have to open a file on that particular case. And they were abusing the program. There's many cases, and I even heard a story about a family that signed over their child to their drug dealer, simply 14-year-old, to the drug dealer because they couldn't pay their drug bills. And it was signed over to a drug dealer. And they, in fact, put the girl into sex trafficking, and it went bad from there. So the thing about juvenile court is they have the arm of DFACS to go out and do home studies and check on these children before they ever grant the order. The probate judges don't have that right, or don't have that ability to do so. And that's why this bill was introduced. And I'll be glad to answer any questions.
Okay, thank you, Representative. We appreciate that. Would you just kind of walk us through the bill, kind of where those changes were made and what the effect of those are? I believe it's the first beginnings, the first meat of the bill, I guess.
Oh,
Oh,
I'm sorry to interrupt you. This is the bill is introduced, so I'm not sure. Are we looking at 464?
464 LC 412891.
Okay, so this is the bill is introduced, so this hasn't been changed since introduction.
No, it has not
No.
been changed. This is the way it was in. There's no substitute.
yeah, there is no sub.
Pretty much the bill is all the same. Pretty much this on line 15, this starts into the order of giving the probate judges the authority to transfer to juvenile court, goes all the way through 21. The other parts of the bill are pretty much the same as it's written now.
Okay. Mm-hmm.
The main change in that was allowing the probate judges to transfer to juvenile.
Okay. All right. And I do apologize, Chair Oliver, if I was confusing whenever I represented changes. I meant changes to the existing statute as opposed
Okay,
to
yeah.
changes to the bill. So,
I hear from Commissioner
yeah, hold on. What is your mic number? So, okay. All right. So I'm not sure who all has signed up to speak to the bill, but I'm certain. Director Rawlings,
Okay.
do you have any comments or anything you'd like to say about the bill? On the hot seat.
So it's on the mic. I don't know if the juvenile court judges are involved
Okay.
in this, but we have not really been involved in this particular bill.
Okay. All right. I know the juvenile court judges have vetted the bill and they don't have any concerns with the bill. So you've, Representative, if you'd like to resume. Okay, so there is the bill. Do any members of the committee have any specific questions with regards to the bill? Again, it is House Bill 464 LC 412891. Representative Hutchinson.
Yeah, thank you, Chairwoman. I have a question about, so the situation that you just described with the family who was giving the child to their drug dealer, how would this bill change that process?
Representative Scoggins.
This bill would change the process simply because if the probate judge did not like the way the bill was, or the petition for guardianship was being proposed to the court, he would have the authority to transfer that case to juvenile court for a further investigation. The way the law is written now, the probate judge would not have a right to deny that petition simply because the law says the probate judge shall issue the order granting the temporary guardianship.
So in that situation, again, going back to that situation, what would the judge have considered unusual that would make him be referred to juvenile court?
Simply because the parents were signing over a guardianship to someone who was not a relative, who was a stranger to the child.
How did he
And
know that?
I'm sorry,
How would he have known that?
how would he have known that?
Yeah.
Probably from hearing it from the child or hear it from the parents. The judge would probably have asked usually the petition asks for the proposed guardian to be, to answer a question of who they are, what the relation is to the minor child. And if it would say, if the petition said unknown or no relation, then that would thrown up a flare for the judge.
So two things about this. First of all, people go to juvenile court and transfer guardianship a lot, and most of them are not relatives. So that would mean in this scenario, the judge would refer a lot of those cases to DFACS. And I don't think that they have the resources to take on an influx. The second thing is, I don't understand how the judge would make that determination. What's to stop a judge from just referring everybody of a certain race, ethnicity, sex to a juvenile court judge? Is there any like probable cause? Because I can see this becoming a problem.
I don't see it a problem. I don't feel like a judge would do that, or I don't think a judge would just issue an order transferring all temporary guardianships over to the juvenile court. It's pretty much an administrative duty right now. All of them do not require hearings, but because it's just the law says you shall do it. So there's not a need for a hearing on each temporary guardianship.
I think you just confused me a little bit more. I would like to, because just doing work in this field, I do know a lot of people transfer guardianship on a daily basis that are not relatives. So that can't be a good probable cause to send that to juvenile court. And I just listening to this makes me feel like DFACS is going to have a lot more work to do, and we might need a fiscal note. So I'd like to hear from DFACS to see if they feel the same way I'm feeling. Like this is going to become a lot of work for an agency that's already overrun.
Okay, Representative, if you.
I didn't understand what you meant. There was a lot of people transferring guardianship. Who is a lot of people? What do you mean by a lot of people transferring guardianships?
Well, in a lot of DFACS cases, and just recently, they opened up the definition of family to include fictive kin. So that happens a lot. A lot of kids are transferred to, their auntie that's not really their auntie, or big mama on the street that's not their grandmother legally, but it's their grandmother emotionally. And
this would not stop them from doing that. The
How?
only thing, this would be allowed for the judge to transfer it if the judge didn't like the direction the case was going.
But in probate court, in guardianship, the judge doesn't talk to the children or the people that are filing the petition. I mean, somebody could correct me if I'm wrong, but I believe it's just a form that you fill out. So I don't know how the judge would.
It is, and that is the only thing. That's why I said earlier when I started the conversation about this bill that is the only thing in probate court that deals with juveniles. All of the other juvenile minor cases are handled in juvenile court. That's the only thing that was done in probate court relating to minors. And they don't have a problem with doing them, but they just don't have a control over them.
So a judge, I'm trying to think, I'm pretty sure they're mandated reporters. So
Mandated what? I'm sorry?
mandated reporters. So if they feel like something is wrong with the case, they can always refer it as a judge, as an individual. I think this can potentially become problematic because I think everyone recognizes that DFACS has too much work and not enough resources. And I'm just leery about giving them a whole new pot of cases because, fictive kin is a huge resource for DFACS. And
The big thing with DFACS was abusing this particular law. And they were sending all those cases down to probate court, telling the people, if you'll go get a temporary guardianship done, we won't do a case up in juvenile court for you. And so that's why they were abusing the case to start with. And we complained over the years about DFACS doing that. And so this is a little ability that the probate judge will have to transfer the case if the judge is not totally acceptable with the guardianship.
I disagree with I think anything can be abused, but I understand why DFACS tells people that. If I wanted to gain guardianship of my neighbor's child, we have a close relationship. My neighbor is incapacitated for one reason or another, then the DFACS worker should tell me, go to probate court so that we don't have to open up a whole investigation and ongoing case. There's no abuse involved. There's no abuse alleged.
Well, I'm not just saying this. I was a probate judge for almost 28 years, so I saw this being abused many, many times in the probate court, and we could not do anything about it. I'm not just speaking on behalf of the Probate Judges Association. I'm speaking on behalf of my experience as a probate judge also.
Perhaps Representative's fresh voice. Director Rawlings, would you like to weigh in on the issue? Chair recognizes Director Rawlings of Division of Family and Children's Services.
Representative Hutchinson, I appreciate your concern over workload. The way this bill is drafted now, I think it's fine. So, and I would recognize that when I was a state child advocate, when I was, over the course of a number of years, we did have that horrible problem. And fortunately, my predecessor, Bobby Cagle, put an end to it, I hope. I do think having this sort of, what do you call it? It's almost like a sort of a gut check or check on
Relief valve.
Sorry?
Relief valve.
Relief valve is actually the word I was trying to think of, the phrase I was actually trying to think of. So that if a probate judge feels that a guardianship is being done for an inappropriate purpose, that in fact, they already had some ability to transfer to the juvenile court previously. The other thing we have already been doing for many years now is dealing with situations where a guardianship was transferred and then there was a disagreement as to whether or not the child should come back to the parent or natural guardian. And so I don't see this as really adding a lot to our work. I do, as Chair said, as a kind of a relief valve to make sure we're not doing inappropriate guardianships. And I've talked to Mr. John over there with juvenile court judges, and I've kind of got some clarity on what this does, and I'm comfortable with it.
Okay. All right. Representative Hutchinson, does that answer your questions?
It does. It does.
Okay. All right.
Not 100% satisfied, but it does answer my questions.
Okay. Does anyone else have any additional questions? Chair Oliver.
I didn't have a question, Madam Chair. I'm ready
Okay.
to make a motion.
Okay. All right. Seeing no further questions, there is I'll recognize you, Chair Oliver, for a motion.
Move to pass.
There is a move to pass for House Bill 464 LC 412891. Is there a second?
Second.
There's a second from Chair Werkheiser. Sorry, I blanked on your last name. I was like, Chair Bill. Anyway, there's a second from Chairman Werkheiser. All those in favor, please signify by saying aye. Any opposed?
Nay, I'm opposed.
There's one opposed. Okay. All right. So noted. Thank you. The measure passes. And I will now recognize Scott, Representative. Sorry, you'll need this. You're welcome. Chair will now recognize Chairwoman Dempsey.
This right?
Yes, ma'am.
Thank you. Thank you. Are y'all comfortable if I take this off? or you
Yes,
want me to-
please
I
do.
know
It makes it
hard-
much,
It's hard to hear. when
Yes.
Someone is talking through it. I know. Good afternoon. Thank you, Madam Chairman, for allowing me to bring HB 548 to you today on behalf of DFACS as well. And so last year, this committee approved House Bill 993. Just to refresh you and to update anyone who might not have been serving on the committee then, it authorized DFACS and DPH, Department of Public Health, to work together to develop policies and procedures for purposes of reporting and to ensure compliance with the federal HIPAA law. It was necessary. We needed to do it. We're in a very similar situation today. That bill passed last year in the House, 166-0, and in the Senate, 52-0. So very well received measure. For those of you on the committee, I want to say thank you for that were here last year. I want to say thank you for doing that. And now, and let you know that legislation has actually made a difference, and it's in similar context that I'm bringing this to you today. So this comes, as I said, also on behalf of the Department of Family and Children's Services. Director Rawlings is behind me and able to answer any specific questions that you may have about it. It will amend Code Section 49-5-41 by adding the new paragraph that each of you should have in front of you. It begins on line 13, the changes there. Basically, there are two separate and distinct systems that need to share pertinent information, data sharing. So Georgia Shines is one. That is the DFACS web-based statewide automated child welfare information system that offers case managers a comprehensive tool for helping children and families. And the second one is the Court Processing Reporting System, CPRS, as it is often called. This secure system allows courts to store court orders and serves as the central portal for all information pertinent to a given case. The purpose of this bill will be to ensure that court orders are upheld, that we in the state of Georgia are in compliance with HIPAA and additional federal regulations governing the disclosure of protected health information, and that federal funding is not put in jeopardy as we receive all eligible reimbursements from the federal government. That is the bill, and minimal changes,
Okay.
but important.
Thank you, Chairwoman Dempsey. Members of the committee, do you have any questions? I see no questions either here or online. What is the will of the committee? There is a motion to pass from Chairman Werkheiser. Is there a second? There's a second from Representative Gaines. All those in favor of the passage of House Bill 548 LC 338627. All those in favor of passage of the bill, please signify by saying aye.
Aye.
Any opposed? Measure passes. Thank you. And with that, we are adjourned.